Good afternoon, everyone. My name is Rafiq. Today I'm going to present the land law presentation. Possible reforms on the positive covenants is my topic for the presentation today. Now I would like to explain what the covenant is. A covenant is an obligation entered into by deed which usually restricts the use of the land for the benefit of another. There are two types of covenants. Number one, restrictive or negative covenants, and number two, the positive covenants. The person who has the benefit of the covenants, in other words, who owns the benefited land, is called covenantee. And the other person who has the burden of covenants, in other words, who owns the burden land, is called covenanter. I will give an example to illustrate the covenant. A is the freeholder of the plot 1 and 2, which are next to each other. A sells plot 2 to B. In the transfer deed, B promises A not to use the plot for business purposes and also to maintain a shared driveway. The important fact is here maintaining. Therefore, A is the covenantee here, who has the benefit of the covenants, and B is the covenanter, who has the burden of the covenants and who owns the burden land, and A owns the benefited land. The benefit of both restrictive and positive covenants runs at common law, if, according to P&A, Swift Investment and Combined English Store Group, it touches and concerns the land of the original covenantee. And also, at the time of covenant, it was intended to benefit the covenantee's land under Section 78, subsection 1, the Law of Property Act 1925. Now I will explain the nature of positive covenants. Generally, the positive covenants fall largely into a small number of categories: erecting and maintaining fence, contributing to maintain a shared accessway, maintaining the appearance of the burden property. These are very few examples of positive covenants. If I go back to my previous illustration, maintaining the shared accessway would be the example of positive covenants, and the other one was restrictive covenants, which was not to use the land for business purpose. Generally, enforcing covenants between the original parties relatively straightforward. For example, if again I go back to my previous illustration, A and B, there should not be problem while enforcing covenants between A and B. However, the problem arises either A or B or both of them are not the parties of dispute. In other words, one of them or both of them transfer their ownerships to third parties. Burden of positive covenants, the current law and the problems with it. As we know, benefit of covenants also runs at equity. However, it is only possible to pass the burden of negative covenants in equity under the Turk and Moxley rule. It is impossible to pass the burden of positive covenants either in law or in equity. According to Gray and Gray, one of the scarcely credible features of the modern law of covenants is that it acknowledges no straightforward means by which the burden of a positive covenant can be transferred to third parties. What is the problem with the current law? The main problem with the current law is the burden of a covenant does not run at common law at all according to Osterbury and Oldham Corporation, 1885. This decision has been highly controversial and widely criticized. However, Osterbury decision was later confirmed in Roane and Stevens in 1994 by the House of Lords. Despite growing dissatisfaction with the Osterbury rule and intense pressure on the judiciary to allow the burden of positive covenants to run with freehold land. Therefore, Lord Templeman in Roane and Stevens said, judicial legislation to overrule the Osterbury case would create a number of difficulties, anomalies, and uncertainties, and affect the rights and liabilities of people who have for over 100 years bought and sold the land. Can the current law be justified? According to some, yes. Land may become burdened with endless covenants which then make it difficult to sell the land freely. The Law Commission report is at pains to highlight how this has been taken into account in the proposed reform with methods to remove and modify property rights described as essential, lest land be sterilized or rendered unmarketable. Law Commission Report 327, Paral 7. Is there any possible methods of avoiding Osterbury rule? Yes, there is. The doctrine of mutual benefit and burden based on Halsall and Brizzell. According to Halsall, if a purchaser takes certain benefits under the conveyance, then the purchaser cannot avoid burdens, even it is positive burdens. And also the conversion of long leaseholds into freeholds. Under Section 153 of the Law of Property Act 1925, this will allow the freehold to be subject to the same covenants as those contained originally in the lease. Now I would like to discuss the possible reform of the positive covenants. Law Commission Report 327, published in 2011, recommended that positive covenants should be capable of binding successors and that a new interest, a land obligation, should be created to encompass both positive and negative obligations. It was not proposed that these changes should be retrospective. In this report, the Commission makes recommendations in 4 areas. Firstly, it recommends simplifying the creation of easement and profits. Secondly, it recommends the new land obligations to take the place of covenants. Thirdly, it recommends adjustment to the land registration procedure to accommodate this interest. And fourthly, the Commission recommends the extension to the jurisdiction of the land chamber of the upper tribunal, which I will discuss a little bit later. Land obligations. The new land obligation would be the vehicle to facilitate the passing of both restrictive or negative and positive promises that touch and concern the benefited land. The benefit and burden of land obligation would be registrable, therefore resolving the current problems in identifying exactly who is benefited by a covenant and who is not. The new land obligation will erase the continuing liability of previous owner. This continuous liability of the previous owners has seen by some commentators as absurd and not fit for purpose. Legal interest. According to Law Commission report, all the positive and negative obligations will be classed together as a legal interest in land, therefore avoiding the confusion what is positive covenant and what is negative covenant and who is responsible for which one. Okay, now I'll discuss enhancing the power of the land chamber. The Land Commission report recognized that it is fundamental that if there to be binding positive obligation, then there will also have to be methods to remove or adopt such obligations where necessary. Extending the jurisdiction of the Lands Chamber of the Upper Tribunal will be able to do that. Giving Land Chamber sufficient flexibility, direction, and resources to facilitate its extended jurisdiction is paramount, according to the Land Commission. The Land Chamber's extended role is intended to guard against land becoming overburdened by positive obligations. As we stand at the beginning of a new year with yet another possible opportunity for reform, after nearly half a century of formal debates, discussions about the reform of the positive covenants, it is time to move on and embrace the advantages of the new land obligations proposed by the Law Commission. The fears of overburdening the land with positive covenants should not let this opportunity be wasted like before. The time has come to act, and there is no some reason to wait any further for the reform of positive covenants. Thank you very much. Thank you, everyone.